Hello, and welcome back to another episode of the Injury Law Pod. I am your host, Eric Bartlett, 29-year personal injury lawyer, and this is the podcast where we talk about all things personal injury law related. And today we've got an interesting one. Would you ever think that a hunting expedition, if you will, could turn deadly or cause injury? And if so, would you ever think that there might be a road to financial recovery when that happens? So, this is a little area of the personal injury law that not a lot of people are really familiar with, but every year there are many hunting accidents that happen. And here in my law firm, we have seen those. We've seen more than one. And generally speaking, we've seen a situation where one hunter does not properly identify what they're going to shoot. And they actually shoot a person instead of wildlife. And so when that happens, there just very well may be a way to get compensated for the injuries or, again, potentially the death that comes out of that situation. So we're going to break it down today. We're going to talk about, again, Missouri hunting accidents, various ways people get hurt hunting. It's not only firearms. And we're going to walk through what it looks like on the legal claim side. And again, how somebody that has been hurt may get compensated for the damages that result. So, what are some common scenarios? I mentioned already accidental shootings, firearm discharges, misidentification of shots. That is obviously a very typical situation when there's a hunting accident. And otherwise, there can be falls from tree stands. A tree stand is what people put up in the trees to elevate themselves when they're hunting certain types of wildlife. And again, there could be falls, there could be a failure of the tree stand, something like that. There could be a harness failure. So, a lot of times these tree stands come with harnesses for added safety. And that is another area for potential harm. There's also the potential of stray bullets hitting somebody on an adjacent property. So, not even somebody that's out actively hunting is injured by someone who is. And also, sometimes people use ATVs or UTVs in hunting. And obviously, there can be crashes on trails or something of that nature, which can cause injury as well. And finally, there can even be dog handling injuries involved in hunting situations. Dogs are used for certain types of hunting, and that certainly is a potential risk of injury. There can also be trips and slips, things like that on rough terrain, property hazards, things like that. So, generally, where do we see these types of injuries occurring? Private farms, leaseholds, public conservation areas, and guided hunts. So, as with any personal injury claim, if you're the person that's injured, what do you have to prove to make a claim against somebody? So, in the legal sense, you have to prove that there was a duty on the part of the person that you're claiming was negligent, a duty owed to you to act reasonably to prevent harm, that they breached that duty, that the breach of that duty caused you injury and caused you damages. And again, then what does that look like in the real world and how does that come together? Let's talk a little more. For example, where someone fires their gun without a clear target. Okay. They have not done what they needed to do to make sure they're shooting at a deer as opposed to a human, right? That's the breach. And then the bullet goes and hits the person that is injured, that's the causation. Pretty simple when you break it down like that. Or again, maybe somebody is shooting at wildlife and that bullet goes astray over into adjacent property and injures somebody. Same deal. They were firing that gun without knowing what the surroundings looked like, who might be around, what property was around there. They hadn't done the appropriate preparation to make sure something bad didn't happen. Again, they breached a duty of reasonableness, and the causation is the bullet causing injury. Now, again, maybe it's a situation where a landowner is allowing someone to hunt on their property or charging for somebody to hunt on their property. And they tell them there's a tree stand out there, there's a ladder, whatever that looks like, and there's something defective about it. The landowner hasn't inspected it beforehand, and maybe it's been sitting there, maybe it was wood, maybe it's rotted, maybe it's rusted, if it's metal. There obviously is a multitude of potential problems with a tree stand if it isn't regularly maintained or taken down or whatever that looks like. Again, that could be the alleged breach of a duty to provide a safe place to hunt, provide safe equipment for the hunt. And then the causation part of it is that the tree stand collapses or some other way is defective or dangerous and causes injury. And then finally, if you're, say, for example, with a professional outfitter, guide, somebody that is charging to take people out to hunt, maybe they failed to do their due diligence in those respects that I've just talked about, or maybe they failed to go over safety rules with the people that are paying them, things of that nature. Maybe they failed to investigate how experienced the people are that are coming out to hunt under their guidance. Again, that would be their breach of the duty they owed to the people that are paying them or they're allowing to be on their property, whatever that looks like. And again, the guest gets injured in some way, and that's the causation. So again, typically, who do we see is responsible in this? Another hunter. Again, an unsafe shot, maybe reckless handling of a firearm. Again, you're around firearms when you're out hunting, and maybe somebody is loading a gun, unloading a gun, whatever, and it accidentally fires. They accidentally pull the trigger, things like that. Again, we see those in the news. If I remember correctly, I think former Vice President Dick Cheney shot somebody on a hunting expedition. And again, it happens. People just don't take the necessary precautions or the time to make sure that they're doing the things to prepare so that something like that does not happen. Again, we see it in the landowner leaseholder arrangement where there's a dangerous condition, there's poor maintenance, there's failure to warn of known hazards, things like that. We also see it in the outfitter guide club type hunting scenario where there's negligent supervision, there's unsafe placements, maybe defective equipment that they provide. And then also, there's always the potential for a product liability situation against the manufacturer or the seller of a product, potentially a defective tree stand, safety harness, firearm, ammo, any of those things could lead to a potential products liability claim. And finally, governmental entities, that's always harder when you're dealing with a government responsibility due to laws that are in place to protect governments. But government entities on public land are certainly a potential area of responsibility. And I won't go into all the details of why a government can't necessarily be sued. There's always limited exceptions to those things. Again, that's why if you're in a situation like this, it's really important. Talk to a lawyer that has been down this road and knows the ins and outs of responsibility and what the law provides as far as being able to get compensated. Now, I talked about in the past comparative fault, and that's always important in Missouri, right? We have comparative fault. And what does that mean? That means your recovery could be reduced by your percentage of fault in the situation. It doesn't mean that you're going to be barred altogether if you share in some fault in this, but you might bear some of the responsibility. And again, that could affect your total compensation you get from the other at fault person. So again, maybe you're in a tree stand and you fall out. Okay. And maybe there was some part of the tree stand that was a problem, but you failed to put on the safety harness. Again, you might be found 50% responsible, and whoever the other party is might be found 50% responsible. Or again, it can go all the way to you being fully responsible, 100%. In that case, you aren't going to get any recovery. But otherwise, if some percentage of fault is found on the person that you're making a claim against, then more than likely you're going to get some recovery for the injuries and the damages that you had out of this incident. Other things that sometimes go along with hunting, which is not wise, but alcohol usage. If for some reason you've sustained injury and you'd been drinking, obviously that's going to weigh heavily against you. And another thing is, what if you're not wearing blaze orange when that's the smart thing to do? That's the reasonable thing to do. And you do get accidentally shot. Again, your fault will be compared to the fault of the person that you're making the claim against. Now, something with governmental entities that you have to watch out for is the recreational use statute. And essentially, that's where landowners, and also it does apply to other landowners, I should point out, but we see this a lot with governmental entities because a lot of governmental entities own property that they open up to the public. And that's exactly what it is. Landowners who open up land for recreation without charging a fee, that's the key part there, are often immune from ordinary negligence claims. So you have to essentially, you have to show gross negligence. You have to show an elevated level of negligence. You're not quite at willful wanton conduct, wanton being a legal term for basically it was pretty much intentional, but you're going to have to show more than just a simple mistake. And you're going to have to potentially show that there were hidden known dangers. That is, the landowner knew about the danger, failed to warn or failed to take care of the danger before allowing people on the land to hunt. And again, if they're charging for people to go onto the land and hunt, then that kind of takes that out of the mix. At that point, they're not giving up the land for free use. And at that point, they fall under the general negligence standards. The basic takeaway here is that an invitee is just what you might think. Whoever it is has invited, if it's a landowner, they've invited the person on the land. And that presents a higher responsibility on them than somebody that's just considered a licensee. And again, I don't need to delve into the weeds of that, but I also will point out if you're trespassing on somebody's land to hunt, not only are you breaking the law, but if you get hurt on their land, you're probably not going to have a claim. It's a much harder standard in that situation to bring a claim against a landowner. Now, another interesting wrinkle could be, what if the sponsor, the landowner, whatever we're looking at, is providing alcohol to the participants? That could potentially expose them to dram shop, what they call it, dram shop liability. And essentially, if the vendor knowingly served a visibly intoxicated person who then caused harm. So again, it could go both ways because let's say they're providing alcohol to all these hunters and there's an accident. Now, not only could we be looking at the person, say, that shot somebody accidentally, but we could also be looking at whoever, if it was a guided hunt and they were providing alcohol, or if it was a landowner, whatever that looks like, that could open up liability in a couple different avenues. The statute of limitations for these types of claims fall under the general statute of limitations for personal injury in Missouri, 5 years, in Kansas, 2 years. And it's always important for several reasons that if you find yourself in a situation like this and you've been injured, it's better off not to wait. Again, Missouri, you have 5 years, which is a good amount of time, but you certainly don't want to sit there if you think you might have a claim and let it go by. And so the other key part I always stress about timing is evidence. So a lot of times with especially like hunting accidents where firearms are involved, there's probably going to be some type of investigation, and whether that's a conservation department, like a game warden coming in, which is usually the case, but it might be police. There's very maybe a report, maybe an investigation, things to help lock down evidence. But if there wasn't, then it's really critical that witnesses are identified, that evidence is secured, maybe the firearm, things like that. Really important. Again, I always stress, if you find yourself in this kind of a situation, don't wait. You got to move on the claim. And again, the best way to do it is reach out to a personal injury lawyer and find out exactly what your particular case looks like. Do you have a claim? And if so, how do you go about pursuing that? So, some examples of evidence that when these kinds of cases, going to be immediate stuff that arises, 911 audio, incident reports, again, game warden, conservation agent, if they come out and they interview witnesses and they take pictures and maybe they confiscate a firearm, things like that. Very important. Scene photos, any video that might be out there. You never know. Did a trail cam capture anything that could be helpful to the case? With the tree stand or ladder situation, you want that preserved. You don't want the landowner getting rid of what is potentially the critical piece of evidence for that kind of a case. Again, harnesses, right? Did a harness fail or something on that tree stand? And again, very critical, especially the tree stand, the harness, those types of things. If you're going to potentially look at a product's liability claim against a manufacturer or seller, you're going to have the product because it's going to have to be examined by experts and it's going to have to be tested or whatever that looks like. And if you don't have it, your claim just got really hard. Also, spent casings from a firearm, the firearm itself, as I've already said, scope settings, all these little things. Again, I mentioned the trail cam footage. These days, there's a lot of trail cameras out there and you never know what might have been captured. Also important is if you're allowed to hunt like through a lease kind of situation, what lease did you sign? What waivers were in there? Things like that could become very important once you get into the nitty gritty of the legal process. Did you waive your rights or did they think you waived your rights even though you really didn't? And are they trying to use that as a defense? Things like that. Again, if you're dealing with an outfitter, a guide, somebody like that, did they go through any safety protocols, anything like that? Did they research the experience of these hunters? All that's going to be important. The other thing too is weather and sunrise, timing, things like that, or maybe even sundown, depending on when the hunting was occurring. You're going to want to pull that information just again to paint a good, solid picture of what exactly was going on at the time this incident occurred. Now, as you move down the road, get away from that immediate incident. Medical is always important. And I always encourage people, and some of these accidents are going to be pretty serious, and medical is going to flow naturally from the incident. But again, later on, is there an emergency room record? Is there an orthopedic doctor involved, or a neurosurgeon, or a neurologist? Was there physical therapy? Were there work restrictions? Again, we're going to want all that in making this claim. I've already mentioned witnesses. Again, hunting partners, guides, adjoining landowners, first responders, all of those people are potential critical witnesses in a situation like this. And then finally, the expert witness situation. Again, some of these are going to require that. Ballistics experts, human factors experts, tree stand engineering, manufacturing, things of that nature, and property safety could even be an area for an expert witness. So when this happens, where does money come from? That's always a big question, because if you're making a claim to try to get compensated for injuries, we got to know where the money is going to be. And as I've talked before, probably many times, an individual, you can sue them and you can get a judgment against an individual, but without insurance, you're probably never going to collect on your judgment. So we're looking for insurance. And believe it or not, for most of these types of claims, either a homeowner's policy will cover the person that is having the claim made against them, or if there's a business involved, there's going to be a commercial insurance policy available to cover this claim. And so a lot of people don't realize that homeowners insurance covers you for your liability, for your potential negligence, not just at your home, but when you're out and you're doing things. And again, now if you're in a car and you cause an accident, there's an exclusion for your homeowners because you should have auto coverage. And usually in a homeowner's policy, there's going to be a specific exclusion for operating a motor vehicle, because again, the expectation is that's covered by an auto policy. But when you're out doing certain things, you very well, your liability could be covered by your homeowners. And it does come into play in a hunting accident situation. And I talk to you about these things because, again, we know we've had hunting accidents in our law firm over the years, and we have had successful recoveries for people that have been injured in hunting accidents. So we've been there, we've done that, we've found the money. But also, you got to remember, if you're pursuing a product liability situation, obviously the manufacturer or the seller of the product is most likely going to have insurance as well. And so that's another avenue. And that's why it's important, because when you're seriously hurt, you know, every penny matters. And it's really important to figure out where the money is going to come from. It's also, again, if there's an ATV type situation, again, a lot of those can be covered very possibly under an auto policy and or under a homeowner's. It just depends. A lot of those are covered under homeowners policies. And so again, there is an avenue towards recovery, but again, you got to know what you're looking for and where to find it. But all of this ties into the necessity for early claim notice and preservation letters. And by that, I mean getting the insurance companies involved sooner rather than later. It makes everything easier the sooner you start a claim with an insurance company. It's harder when something happened 3 years ago and you're bringing in an insurance company and they're wanting to know, what is this all about? What evidence do you have? And again, if you've let time go by and you don't have it, it's going to be a very difficult claim to make. Now, outside my personal experience in our law firm, there have been some Missouri cases. And for example, there was a case where there was a tree stand collapse on private property, and the issues there, just as I've already discussed, was the recreational use statute versus the known danger exception, where again, the landowner knew about the danger, but did not warn or take care of the danger. Again, landlord versus tenant responsibility, like who exactly is on the hook when there's multiple players involved in the ownership, so to speak, of the property. And again, in that case, there was also an issue about the tree stand getting tossed and whether they had been put on proper notice to preserve the tree stand. That way it would be there for evidence. And if you put somebody on notice early on that they need to hold on to whatever it is that's at the center of this and they get rid of it, then that's a potentially useful thing in a subsequent lawsuit coming out of this, because you can show that the party that had control of the product got rid of it after they were put on notice that it could be important. So again, all crucial things for acting early, making sure you're taking the correct steps. There was another one where there was a stray bullet injury on adjacent property, like I mentioned. And again, there the issues were whether there was a safe backstop, a line of sight, target identification, and again, comparative fault, was the victim wearing orange, those types of things. So it encompassed a whole bunch of these issues that I've talked about previously. And again, there, the insurance that was involved was the homeowner's policy that was in place. There was a guided waterfowl hunt that involved a boat and a shotgun mix up. And there, the issues were the guide safety briefing, boat loading, unloading protocol, negligent supervision by the guide. So all of these things were being alleged around this incident. And the defendants there were the guide service, the individual hunter, and there was also a comparative fault analysis in that one. Real quick, let's talk a little more in depth about waivers. I mentioned it here a few minutes ago, and hunting waivers, there's assumption of risk. What does all that look like? Again, what I always emphasize is that you might sign a waiver, a landlord, property owner, guide, whoever that is, might present you with a release, a waiver, so that you can hold them responsible if something happens. But that's not an automatic shield. And that's what you always have to keep in mind. There can be vague language, there can be gross negligence carve outs, or there can be a mismatch with what actually happened and what was supposedly waived. So again, that takes a lawyer, right? Looking at the waiver and figuring out, is it actually going to protect the landowner, the guide, whatever, or not? And again, with assumption of risk, there's an analysis about primary versus secondary assumption of risk and how it interacts with comparative fault. The general idea is with assumption of risk, if you're partaking in some activity that carries a risk with it, does that completely prevent you from making a claim if you're injured out of it? And again, that's a rabbit hole that we don't have to go down, but it's an issue that does come up. But it doesn't, there, by no means are you ever precluded entirely from making a claim out of a situation like this based on assumption of risk, but it can be an issue. What we have found over time is that juries still expect basic safety, even in risky activities. And again, you can think about a baseball game that you might go and watch. Maybe you are playing in a softball league or something like that. Okay. You obviously are assuming the risk of certain types of injuries if you're playing in a game. There's no question. But what if somebody does something that's just not the natural course of that game? Okay. That's a different story, right? And it's the same with a hunting situation. Again, sure, there are certain risks involved, but should somebody be able to shoot somebody else and get away with it? Because, well, you're out there with guns, so it's a free for all. Obviously, I don't think any of us think that way. and juries certainly do not. And they've shown that with jury verdicts in favor of hurt people from hunting type situations. Okay, if you find yourself in a hunting accident, injury situation, again, can't stress enough, get medical help, call 911, get authorities out there, get them preserving everything. Again, if it doesn't rise to that level for some reason, you got to make sure the scene and the equipment and everything that's involved is preserved. Don't fix anything, don't throw anything away. Again, you need to put whoever the owner is of the equipment or whatever's that issue on notice, not to fix things, not to throw things away. It needs to be preserved. Again, photograph everything. Today, our world, pretty easy anymore. We get lots of pictures from clients, whether somebody shows up at a car accident scene and they take the pictures, witnesses take pictures, video, whatever that looks like. Usually these days, there's plenty of photographs and video, and you want to make sure those are in existence and that they stay in existence. That's the key. Again, get names, phone numbers, everybody present. Again, something for a lawyer to do, potentially, maybe you note the land boundaries, try to figure out what the lease terms were, things like that. Again, that's a little heavier lifting, probably best for a lawyer to do. Don't argue fault on the scene or on social media. You just let lawyers handle that kind of stuff. And basically, then again, I can't stress enough, you need a lawyer that has been in this situation, has seen it, has handled it, has recovered money for people that have been injured. So I would be remiss talking about wise things to do if you're out hunting. And again, everybody has to go through a hunting course, but it's always a good reminder. Make sure you're wearing a harness if you're climbing, if you're in a tree stand, if you're shooting, make sure you have clear backstops so you know that bullet isn't going to just continue to travel to wherever you don't know. Make sure that you ID the target beyond a doubt. You only get one chance to pull that trigger, and you got to make sure you're shooting an animal and not a human. And again, it's never makes no sense to have alcohol involved in a hunting activity. And in between hunting seasons, before you're going to go out and hunt, those tree stands and things, that equipment, it needs to be maintained and it needs to be inspected. Landowners, again, they need to inspect and retire old tree stands. They need to mark hazards that they know about. They need to make sure there's written permission policies. And again, there needs to be no fee clarity if you as a landowner are going to rely on the recreational use statute. Because again, if you're not charging, that's one thing. If you're charging, that's another thing. So that all needs to be taken into account if you're the landowner allowing hunting or even other activities on your property. And outfitters, guides, those types of people, they need to have documented safety briefings. They need to have gear checklists. They need to have incident logs, stand logs with install dates, maintenance, and inspection. Because again, if you're the one getting sued, you need to be able to show, hey, this is what we've been doing. We took reasonable actions in providing a safe opportunity for people to hunt here. All right. I hope you never face this situation. I hope you're never hurt in some type of a hunting accident. But unfortunately, every time we look at the numbers, there are many people hurt during the hunting seasons through accidents like I've just talked about. So again, if you find yourself in that situation, do not hesitate to reach out. Call us. It's always a free call. We're happy to investigate the situation and see if we can help you recover or a potentially serious injury or even worse. And until the next episode, as always, be safe and be well.